My name is Marie. I'm from Rancho Palos Verdes, California. I'm a longshoreman and I work at the LA Long Beach harbors. A very good friend of mine went through a court divorce and I helped him file his papers. While I was doing so, I saw some very bad things there. I'd like to read a statement by him that records what went on during that divorce. His statement: I was served notice by my wife and her friend at work on January 19, 2000. I had interviewed 2 independent lawyers in the beginning. The first never contacted me after I retained her, and the second one was going through a divorce himself and was not able to focus or concentrate on preparing for my first hearing date. From good sources, I heard about Miss Katrina West of Covington and Crow, her firm was located in the county where my case was filed. A week prior to the first court date, Miss West accepted my retainer. At the beginning, at the first hearing, Miss West represented me very well. She even started to raise the issue of my wife's breach of fiduciary duty during the marriage, but stopped herself in mid-sentence. I felt I'd made an excellent choice, which the transcript will show. Despite her efforts, however, the court ordered me to pay the maximum alimony amount for my wages. Later, I showed Miss West a falsified expense report submitted by my spouse. She noted but did not object to the falsified papers or the resulting alimony orders. Later on, I advised her of my recent discovery that my spouse had been forging my endorsement on the back of my credit union checks made payable to me. Miss West said this was irrelevant to the case and that I would have to take this to another court, which would delay the divorce proceedings. She recommended that I see a civil attorney, so I consulted with her and civil attorney Melanie Fisk of Covington and Crow together. They concluded that this was a sticky issue and they did not want to get involved. Legal counselors at the Victorville courthouse said I should file criminal charges against my spouse for the forgery and the grand theft, which I did. The next month, the sheriff advised me that this forgery is a civil matter because of the divorce, and the matter should have been presented to the judge by Miss West, and that the district attorney could not address this matter because of the divorce case. This left me with no recourse for the loss of savings I had set aside for our retirement. There was no communication between me and Miss West until 4 months later, when I wrote her a letter asking about the status of my case, particularly on getting the alimony reduced. She justified it, saying, "In similar cases, many men in similar situations have paid disomaster support for years because the wife refused to work." I was annoyed with this, and again, there was no communication for the next month between me and Miss West. I began to consider that my outcome in this case may not be in good hands. Where was the advocate lawyer who represented me in court? I was worried about her abrupt change in demeanor towards my case. On the advice of a private investigator I knew, I interviewed J. Michael Kelly, an attorney in Santa Monica, Los Angeles. During this interview, I told Mr. Kelly that since the case began, I have had no idea where my former spouse was living or whether she was working or not. Mr. Kelly called Miss Honeywell, the vocational evaluator who was hired by my former attorney, Miss West. Honeywell reported that my spouse was scheduled for surgery on a 20-year-old problem on her neck. My former attorney had no knowledge of this. I retained Mr. Kelly that day, and we made an appointment for January 3, 2001. On that appointment, Mr. Kelly said a lifestyle study should be done to better ascertain an alimony amount at judgment. Mr. Kelly was asked by the accountant to issue a demand letter to to my former spouse and her counsel, Daniel Nishiyama, who has a public record of discipline for bribery. Throughout the proceedings, my estranged spouse refused to release financial documents to me, including my own paycheck stubs, credit union statements, and especially credit card transaction histories, all of which were needed for the study. Not surprisingly, no demand was made. By now I knew something was very wrong with this case, but I didn't know what. Under the counsel of one of Mr. Kelly's associates, 5 subpoenas were issued for information on the credit card debts I was paying off. 2 subpoenas to accounts I already knew about were fulfilled. The remaining 3 subpoenas, ones I did not know about, were not fulfilled. These remaining 3, the ones I did not know about, I'm sorry, I've already said that. I contacted the 3 creditors myself, and two of them told me that they had no record of being subpoenaed. One of these 2 told me there was on file a letter from my former spouse's attorney saying he will handle anything further, and I was denied access to information on that account, even though it was said to be joint and I was paying the debt. Why was I denied information about accounts that were joint, opened during the marriage, and should have been community property? Then I got a letter from the 3rd creditor saying they will comply with the subpoena unless a court order says otherwise. I forwarded this letter to my attorney, Mr. Kelly, and heard nothing from him. I then went to his office to ask him personally why a creditor would send such a letter and then not comply. He became agitated, gave me my money back for the 3 unfulfilled subpoenas, and told me not to ask again. Then I received another mailing from them, the creditor that had just mailed me. I got another letter from them, and enclosed was a copy of the original application for credit showing my forged signature. Throughout the case, there were 5 hearings scheduled where I would have had a chance to address these matters in front of a judge. Those hearings were all continued or vacated. The mandatory settlement conference was held in Victorville. I submitted my current material facts, but my former spouse did not, and my lawyer didn't find it necessary to tell me. My current financials revealed that I had reopened my credit union savings account. Seeing this, my former spouse made a false promise which gained my signature on the judgment. This allowed her to later use the judgment as an instrument of coercion in forcing me to sign other documents that would have been linked to my reopened credit union savings account, which she had already breached. It is my contention that this ought to have invalidated the judgment. Both my lawyers and opposing counsel together urged me to waive the $45,000 reimbursement claims I had earned, to accept the remaining $38,000 credit card debt for a reduced alimony. Now I wanted a trial, and for 4 hours I resisted the lawyers. Feeling tired of arguing, I acquiesced. No judge was present. Angry that my spouse could arbitrarily withhold financial information from me and the court, file falsified material facts with me and the court, forge my endorsement on checks and credit card applications, and enter a false promise into the judgment so it could be later used as an instrument of coercion against me without consequences, I filed a detailed complaint to the State Bar Association. 2 months later, I received their response, which said, "As to your complaint that Miss West and Mr. Kelly failed to object to your spouse's false claims regarding the expenses and failed to subpoena information that would have proved that your wife misappropriated funds, what you are complaining about is the discretionary manner in which your attorneys chose to handle your case. Please be advised that such errors in judgment by an attorney do not provide grounds for disciplinary actions against the attorney." At this writing, I am 68 years old. I want to retire, but I'm afraid because it was pointed out to me recently that my lawyers did not include an alimony termination date in the judgment, which means that I could be paying dual compensation, both pension and spousal support payments, after I retire. I do not believe this was an oversight. I believe this omission was one of probably many deals where opposing counsel bought out my counsel.